This is the time set for oral argument in the matter of Risas Holdings LLC versus Brandon Tackett, our civil number 20-0150. We are holding this oral argument in a virtual fashion in response to an unopposed motion, which we granted. We are recording the proceedings. Each side will have 20 minutes within which to present their argument in this matter. Appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of your time in that regard. We have reviewed the briefs. We've been through the record. We have conferenced the case. So we are familiar with the underlying facts and the issues that you have brought before us here today. So please keep that in mind as you make your arguments here today. With that, counsel for appellant may proceed.
Good morning, and may it please the court, Olivier Bibo for defendants, appellants Brandon and Catherine Tackett. The genesis of the lawsuit in the trial court was the assertion that Mr. Tackett was stealing Risas's confidential information and trade secrets and using them in his new business to unlawfully compete with Risas. The backdrop to the discussion over attorney's fees and costs is Risas's goal in bringing suit was always, one, to prohibit Mr. Tackett from competing with it in any respect after he left its employment, and two, to secure a monetary award of all the profits Mr. Tackett and his business had earned after his employment terminated. Risas's position was that any competition by Mr. Tackett and his businesses constituted a violation of his confidential information and trade secrets. The foundation for this position was always alleged to be the confidentiality agreement Mr. Tackett had executed with Risas management. And the debate over the confidentiality agreement and what restrictions it imposed on Mr. Tackett, if any, led to 2 years of contentious litigation. The outcome of the confidentiality agreement dispute was determined on the merits by summary judgment and decided in favor of Mr. Tackett and the Somos companies. Every claim for breach of contract or related to the confidentiality agreement, confidential information, and trade secrets was decided by summary judgment in Mr. Tackett's favor. That's to say that,
wasn't those resolved after the parties had agreed to a permanent injunction on confidential information and the use of the Risas employees for a period of time?
No, I would answer that no, Your Honor. And let me explain the consent decree. So 6 weeks after the case was filed, the parties entered into the consent decree that you are referring to. It was entered at the suggestion of Mr. Tackett. The reason being that there were a few provisions of the confidentiality agreement that were not in dispute. Mr. Tackett did not dispute that there was a restriction on soliciting employees, and he didn't dispute that there was a restriction on his use of certain discrete documents. And so to streamline the case, he suggested that he would agree in the form of this consent decree not to use those moving forward, because the debate in the case was not over these restrictions. What it was over was Risas was attempting to use the open-ended language in the confidentiality agreement to restrict Mr. Tackett from engaging in any competition. There was no non-compete in the confidentiality agreement. So the tack that Risas took was to prevent Mr. Tackett from competing. It was going to argue that anything he did was in violation of the broad restriction on confidential information in that agreement. And so that's where the dispute was. It wasn't over employee solicitation. It wasn't over use of of discrete documents. It was over this open-ended language in the confidentiality agreement that Risas could use however it saw fit to try to prohibit Mr. Tackett from engaging in competition. So the idea was to streamline the case by entering into this consent decree.
Did anyone ever challenge the scope of the agreement?
The scope of the agreement was challenged, and the trial determined that the confidentiality agreement was invalid on its face. That was determined by summary judgment.
Okay.
Yes. And so our take, in our view, is this consent decree was not the result of any contested issue. In fact, it was entered before the Tacketts even filed their answer in the case. It was a preliminary stipulation, essentially, to streamline the case and focus the parties on the true dispute. And of course,
well, counsel, you would agree that that in the complaint, Risas sought equitable relief in the form of both temporary, preliminary, and then permanent injunction, and they achieved that result.
No, I would disagree with that, Your Honor, and here's why. In the complaint, the restrictions and the injunctive relief that Risas was seeking was an injunction on Mr. Tackett engaging in his new businesses. That was the injunctive relief that it sought. The consent decree was far narrower in its scope than the request for injunctive relief that was sought by Risas in his complaints. And I'll add here that Risas filed 2 amendments to its complaints after the consent decree was entered, both of which sought injunctive relief. So the contention by Risas that it got everything that it wanted in the form of injunctive relief is belied by the complaints themselves that it pursued for 2 years after the consent decree was entered. And of course, as it relates to attorney's fees, the idea and the purpose behind the fee shifting provision in the confidentiality agreement is to award fees to the party who has the meritorious claim or defense, which in this case was unquestionably Mr. Tackett. The merits of the confidentiality agreement provisions were all decided in favor of Mr. Tackett, and that includes the employee solicitation claims and misuse or improper use of discrete documents that were in the consent decree. And so let me explain that further. Risas contended not only that it had an open-ended ability to restrict competition, but that Mr. Tackett had violated the employee solicitation clause and used the documents that are in the consent decree. It did not prove and failed in those breach claims. So those breach claims were made as it relates to Mr. Tackett's conduct before and after the consent decree was entered, and it failed on the merits. So,
well, counsel, what about the settlement of the fiduciary duty, the breach of fiduciary duty claim? Did that duty arise out of the confidentiality agreement?
It did not. And this is an important distinction here. This is not a case, as we see many cases in Arizona authority, where the courts are wrestling with, does the tort fall within the ambit of the contract? Are the claims intertwined? Is the tort claim arising under the contract dispute writ large? In this particular case, the trial court actually made a ruling. When the Tacketts filed and petitioned for a bench trial of the fiduciary duty claim, the issue arose, well, is the fiduciary duty claim a claim that arises under the confidentiality agreement or not? Because there's a jury trial waiver in the confidentiality agreement. And the trial court decided definitively that the fiduciary duty claim was not a claim that was related to the confidentiality agreement, did not arise under it. So by the time that the parties got to the attorney fee determination at the end of the case, the trial court had already decided that the fiduciary duty claim was outside the scope of the confidentiality agreement. And that's critical in the analysis, because the universe of claims that the court was to look at in deciding who the prevailing party was already set. And it was set to include only those claims that related to the confidentiality agreement. It excluded the fiduciary duty claim. And given that that was the case, the trial court could not rule other than in favor of awarding the Tackett's attorney's fees, because all of those claims, every single one of them, was decided in favor of the Tackett's. And so that is the reason that we have argued that this court can review de novo certain aspects of the trial court ruling. The confidentiality agreement, as a function of contract interpretation, only covers claims that are related to the enforcement and interpretation of the confidentiality agreement. And the trial court got it wrong in its attorney's fees award when it said that it could consider all claims in the case. It had already decided earlier the fiduciary duty claim was not to be considered as part of the confidentiality agreement. So it got it wrong in that respect. I'll touch on a couple other items in our brief before reserving the balance of my time for rebuttal. The trial court did not address the trade secrets fee request that was made by the Tackett and was and should have done that in our view. So there are two issues there. One is whether the court could even do that under the statute. Risas says it couldn't because only fees can be awarded to the complainant, only to the plaintiff. Well, the language of the statute provides that the prevailing party gets its fees, which includes both the complainant and the respondent. And so the trial court should have considered that and failed to do it. It's a discretionary award, and it may, in the end, not matter much if the Tacketts are awarded their fees under the contract, but it should have at least considered it, which it failed to do. And secondly, in entering the final judgment, the court included language that was proposed by Risas that Risas had succeeded on count 4. Count 4 is the injunctive relief claim. For the reasons I mentioned earlier as it relates to the consent decree didn't resolve the injunctive relief claim. Furthermore, the injunctive relief claim is tied to the breach of contract claim. So count 4 was only a claim for relief. There was no substantive claim there. It was tied to the contract claim. So because Risas lost the contract claim, it also lost count 4. And so it was error for the court to include that language in the final judgment. And if there are no further questions, I'll reserve the balance of my time for rebuttal.
All right, I'm waiting a moment to see if the panel has any questions for you. Hearing none. Mr. Frazier?
Good morning, Your Honors. First things first, can you hear me and see me?
I can.
Yes.
Great. May it please the court, my name is Eric Frazier, and I represent Risas, the appellees. This was not an anti-compete case. That's not what's in the record. And Judge Swan, you asked whether the scope of the agreement was challenged. It was challenged both before and after entry of the consent decree. Mr. Tackett filed a motion to dismiss before entry of the consent decree, where he alleged that the agreement was narrower than Risas' interpretation, alleged that it was unenforceable, all those things. In that motion to dismiss, he also characterized the first return hearing that he now says was essentially a ministerial act, characterized it as one that involved substantive questions about the enforceability of the agreement. That's why the consent decree is so important. We did not get everything we asked for. Our position is not that we achieved everything, but we achieved 3 of our core litigation goals, which allowed the trial court to find that we were the prevailing party. Maybe that didn't require the trial court to find that we were a prevailing party, but it allowed the trial court to find that we were the prevailing party. The consent decree is still in effect. It is not subject to defenses about enforceability. So if Mr. Tackett claims now or claimed during the litigation that it was unenforceable due to lack of consideration, or his signature was a forgery, or what have you, the consent decree is not subject to those types of defenses. It is binding. It is enforceable via contempt. We don't have to bring a breach of contract case. We can bring a motion for sanctions under the consent decree. The consent decree achieved the material alteration in the parties' positions. To hold otherwise would be to hold that a contract has the same effect as a judgment from the court. It doesn't. The consent decree, particularly because it's still enforced today and was reaffirmed in the judgment, remains binding and remains enforceable against Mr. Tackett. So we have ongoing permanent injunctive relief that survives the judgment and is still in place today.
Mr. Frazier,
yes.
Mr. Frazier, this may not be the right time to ask, but I'm curious as to your response to opposing counsel's argument that in the amended complaints that were filed, additional injunctive relief was sought and apparently rejected by the court. And I'm wondering how that folds into this argument you're making about the injunctive relief having satisfied one of the core goals of the litigation.
Absolutely, Your Honor. So we are not claiming, again, that we achieved all of our litigation goals or all of the injunctive relief that we sought, but we have meaningful injunctive relief now, and that did resolve the claim. And here's why. If I sue for breach of contract and seek $100,000 in damages and get $50,000 in damages, that still resolves the claim. If I seek an injunction that lasts 10 years and covers X, Y, and Z, and the court gives an injunction that lasts 1 year and covers just X, not Y and Z, that still resolves the claim. It gives the court discretion to find that we achieved our litigation goals or we were the prevailing party. Again, different judges might come at this in different ways. And so if our injunction is narrower in scope than what we sought to achieve, maybe one judge could find that the other side is the prevailing party, but it doesn't require the judge to make that finding. It gives the discretion to the trial court judge to find that we prevailed because we achieved some of our core litigation goals. We spent quite a bit of space in our answering brief, and I apologize for that, but I think it's important, comparing the text of our complaints, all three of them, the complaints to the consent decree, because there is a one-to-one correlation on substantial portions of the complaints and what we achieved in our consent decree. So the notion that we didn't get anything is just not true. We were seeking to enjoin Mr. Tackett from poaching our employees. We were seeking to enjoin Mr. Tackett from using our confidential information spelled out in very, very specific items, the Google Drive, the emails, the Risas Way manual. That is exactly what we achieved in an injunction. And once we have that injunction, it's valid and it survives the judgment. It's reaffirmed in the judgment and it's still enforceable today. The totality of the litigation test, which is what everybody agrees applies here, and is exactly what the trial court did, allows the trial court to consider the whole case. That's what it's called, the totality of the litigation. And this court has released two opinions that I think are really relevant here, the Murphy case and the very recent Arizona Biltmore case, where the court faced cases like this, where it's complex litigation, multi-claim cases with mixed outcomes, where only some of the claims were fee eligible. So again, complex litigation, multi-claim case with mixed outcomes where only some of the claims are fee eligible. And I think in both of those cases, the court's opinions at least suggest that the trial court can consider the entire case, because the totality of the litigation test means the whole litigation. It takes a holistic view. Who won the case? And in the contract here, the relevant contract term asks who prevailed in the action. The action is the phrase that the contract uses. It doesn't just say the claim, because if you take a step back and think about how this can work, step one is figuring out who won the case. And if you read all of this court's opinions, it's a holistic view that you just ask who won. And after you determine who won the case, then the court has to look at the individual claims to determine which ones are fee eligible. That can affect how much you award in fees. So we agree that the court cannot award fees on non-fee eligible claims. It did not do so here. That's not what happened. But that analysis, figuring out which claims are fee eligible, happens after the court, or can happen after the court determines who won the case overall. That is
Mr. Frazier, let me ask you this on the fees. Mr. Bebo has argued that at a minimum, his client was eligible for consideration of a fee award as it relates to the trade secrets claim. Now, if in fact that is true, assuming that is true, was that an error of law that should justify vacating this award?
No, and there are several reasons, Your Honor. First of all, because the trial court concluded that we were the prevailing party in the entire case. So that's step one, right? But step two, even if you need to look at this claim by claim, the trial court never has an obligation to state its reasons for exercising its discretion to deny a fee award. I'm sure you've seen many minute entries that say fees are denied, period, without any explanation. And although this court has said that that's not the best thing to do, that's a permissible thing to do. But more importantly, this is not an error of law. To trigger Section 3 under the Trade Secrets Act, there has to be a finding of willful and malicious misappropriation. The statute says that a court may award fees for willful and malicious misappropriation. That modifier for applies to all of the subparts. It doesn't say a claim of willful and malicious misappropriation, which is what it would have said if that triggered a defendant to claim fees anytime there is a claim of willful and malicious misappropriation.
I don't think the statute says that the fee award goes to the prevailing party who proves there's been a misappropriation made in bad faith, or the rest of the other subsections. The way I'm reading the statute is that the court may award reasonable attorney's fees to the prevailing party on any of the following issue if the following issues are alleged, which seems on its face to allow the defendant to be eligible to request a fee award if in fact they are successful on those claims. And it seems like that would be consistent with the way other Arizona fee statutes are interpreted.
So, Your Honor, with respect, I don't think that's the best reading of the statute, because if you look at Section 1, Section 1 is the only time where the statute allows a defendant to claim fees because of the claim that the plaintiff asserted. And there it requires bad faith, which makes sense, right? So a defendant can get attorney's fees if a plaintiff makes a claim in bad faith, which was never alleged here. And a defendant can get attorney's fees for willful and malicious misappropriation. Again, if you look at that word for, that modifier for applies to all three subsections. So if you take that down, for malicious and willful and malicious misappropriation. Structurally, I don't think it makes sense to say that a defendant can get fees if the plaintiff acted in bad faith, which is looks at the plaintiff's conduct, or any time a plaintiff alleges willful and malicious misappropriation. Plaintiffs allege willful and malicious appropriation almost every time they allege a violation of the Trade Secrets Act. And there's no case that has ever awarded fees that I'm aware of to a successful defendant just because the plaintiff made a claim of willful and malicious misappropriation in good faith. Right? There's never been a finding of bad faith, which would trigger Section 1. So for good faith claims, the defendant doesn't get a fee award under the statute. The statute clearly, I think, is designed to give the defendant a claim for fees if the plaintiff acts in bad faith when asserting a claim. And I think that's true, especially the Uniform Trade Secrets Act. And I know structurally it's a little bit different grammatically, but it's clearly aimed at the same objectives. And of course, we cited a case on that as well. But again, even if you disagree with us, the Superior Court has discretion to deny that fee award and does not have to explain its reasons. So I don't think that's a reason to reverse and remand. Briefly on the summary judgment ruling, Your Honors, The summary judgment ruling on the contract claim does not require the trial court to reach one conclusion or another on the prevailing party analysis. Mr. Tackett's theory is that once summary judgment was entered in his favor on various claims, that required the court to find that he was the prevailing party. That's not true because, again, you look at the overall litigation and the relief that we achieved. Maybe a different judge could have determined that the summary judgment ruling was more important in the overall litigation, but it wasn't required to. This judge thought that the injunctive relief that we received and the monetary award that we got were more important. That is completely permissible. That is within the broad scope of discretion that we give trial judges, because this trial judge sat with this case from beginning to end. And some cases are close calls, but we don't want to create incentives to appeal every fee decision that a trial court makes. Fee decisions are already complicated enough. We don't want to remove discretion from the trial court. This judge sat through the whole case, saw that days before the hearing on the preliminary injunction, Mr. Tackett caved and gave us a substantial part of what we wanted in permanent injunctive relief. This trial court judge saw that right before the jury trial, Mr. Tackett caved and gave us monetary relief that we've been seeking. This trial court judge then acted within the scope of his discretion in finding that we were the prevailing party when taking a holistic view of the overall success in the case, looking at the totality of the litigation under Arizona law. The real question is who won. We had three key litigation objectives. I know you've heard this. If you'll indulge me, I'll say it again. We wanted to enjoin the use of our confidential information, enjoin poaching of our employees, and recover damages. We got all three things. We did not achieve the scope that we wanted necessarily, but we achieved meaningful, substantial relief on all three things. $80,000, ongoing relief that doesn't expire until 2021. This is a very, very forgiving standard of review. You affirm if there is any evidence, any rationale that supports the ruling, and for good reason. Again, this is the trial court judge that saw the whole case. Be happy to answer any questions you might have.
All right, we'll pause for a moment for the panel. Hearing none. Thank you, Mr. Frazier.
Thank you, and thank you for indulging us by video. Very much appreciated. Thank you.
Certainly. All right, Mr. Bebo.
Yes, Your Honor. So I'll start with the consent decree. My counterpart referenced the motion to dismiss that was filed just before the consent decree was entered. Now, that motion to dismiss addressed the case in whole, and really its focus was on the same issues that were at the center of the motion for summary judgment that was ultimately decided in the Tackett's favor. So there was no contest as it related to these two items, these two subsets of the confidentiality agreement that were in the consent decree, and the Tackett's acknowledged this in their motion to dismiss. And I'll just take the string a little further here to explain that a little bit better. So in the confidentiality agreement, there was a restriction on employee solicitation. Risas's argument was that that solicitation provision could be expanded to cover referral doctors, independent contractors, and even vendors. And it was this expansive interpretation of the confidentiality agreement, again, that the Tacketts opposed, not the limited application to employees, which is what is actually stated in the confidentiality agreement. So there was no contest on these issues, I want to be clear, that are in the consent decree. And I think we need to just take a practical look at what happened here. The consent decree was entered 6 weeks into the case. If the consent decree afforded Risas all the injunctive relief that it wanted, why did it continue to litigate the case for 2.5 more years at considerable expense, hundreds of thousands of dollars? And it pursued vigorous litigation tactics. There were a whole host of depositions that were taken, over 10, subpoenas, discovery requests, very contentious litigation. The Risas parties, both Risas Holdings and Risas Management, did not have free license to heavily litigate the case, free of risk of an adverse attorney's fees award by virtue of entry of the consent decree. If the Risas parties really got what they wanted, then they would have stopped litigating and they would have put forward an application for attorney's fees based on the consent decree 6 weeks in the case. They didn't do that. And I would add, they didn't apply for attorney's fees at the end of the case. If the consent decree really afforded them all the relief and they really believe that they were the prevailing party by virtue of the consent decree, then certainly they would have applied for attorney's fees under the confidentiality agreement. They didn't do that. The confidentiality agreement, I want to emphasize, controls. It's not 12341.01. We made some arguments as it relates to 12341.01 in our motion for reconsideration down below in the application for attorney's fees and even in our briefing up at the Court of Appeals here. But the reason we did that really was as a secondary argument in the event that Risas was going to argue that not all of the claims that were awarded on summary judgment fell within the scope of the confidentiality agreement. But they didn't do that. So really the focus here is on the confidentiality agreement itself. The confidentiality agreement's attorney's fees provision controls. And this is important because many of the cases that were cited by Risas as relates to the totality of the litigation are cases that analyzed all the claims in a case under 12341.01. And as I mentioned before, the confidentiality agreement attorney's fees provision is narrow in its provision of what claims qualify for fees, what claims are fee eligible. And in this case, Judge Swan?
We step back for a moment, though.
Yes.
I mean, Mr. Fraser, yes. Can you hear me okay?
I can hear you just fine, yes.
Okay. Mr. Fraser makes the point that a different trial judge might have come out a different way. And I wonder if that discretionary point is getting lost here. Because really under the standard of review, unless you disagree and want us to consider a different standard of review, we would have to conclude that no reasonable trial judge could have come to the conclusion that your opponent was the prevailing party. And that's a much different standard than some of the arguments you're making, which have some persuasive value, but aren't necessary. So can you address this within the context of that standard of review?
Yes, I can. So there are two steps to the analysis. The first step is what claims are fee eligible. That's a function of contract interpretation, which is reviewed de novo. It's not discretionary. So when we set those boundaries, we set the universe, the totality of the litigation for purposes of the confidentiality agreement. That excludes the fiduciary duty claim. And I heard Mr. Fraser argue earlier that the court did not consider the fiduciary duty claim when determining the prevailing party status. It did.
Let's assume for a moment that it didn't. Let's assume that we were to rule that it couldn't. Does that mean that it's still an abuse of discretion to find in your favor?
Yes.
I mean, in the other side's favor. The injunction alone is not basis for the court to conclude that the other side prevailed.
Yes, that's correct. I would submit, and I do submit, that it is an abuse of discretion for the court to determine that Risas won the case, that it was the prevailing party under the confidentiality agreement based on the consent decree alone.
You're familiar with the cases that go to trial and everybody thinks it's a multi-million-dollar case. The jury comes back with 20 grand. In that case, who's the prevailing party?
Well, it depends on the facts of the case, certainly.
Not really. You've got a wrongful death case, millions of dollars in claim damages. The jury comes back with $20,000. Who prevailed in that case?
In that particular case, the the defendant would prevail.
Well, I mean, I think many of us would agree with you. But would it be an abuse of discretion to say, hey, the jury ruled for plaintiff? Plaintiff prevailed?
No, I don't think so. And here's the distinction. It comes down to this contested issue that the parties are arguing in their briefs. The consent decree was not contested. And so this distinguishes it from the facts of the cases that were cited by Risas. If these aspects of the consent decree have been contested, they were subject to motions, disclosure statements, what have you, over the course of the case, and then there was a consent decree that was entered, okay, well then there's an argument to be made, and the court can have discretion to consider that in the context of the prevailing party analysis.
About the point that there was litigation before this injunction was entered. I
mean,
there was a motion to dismiss, right, based on the enforceability of the agreement.
There was, but not on these particular aspects of the agreement. And so maybe that's getting lost here, is that the consent decree is very narrow in its scope. It's essentially a recitation of the contract. And there is, of course, reservations as to all the claims and defenses, including injunctive relief claims under the consent decree. There's the Buchanan case, which is a Supreme Court case, which we cited. And in that case, it goes into when is a party the prevailing party. And in Justice Scalia's consenting opinion, he says just because someone alleges something and the other party later agrees to it doesn't mean that there was a debate over it. Doesn't mean that the party who alleged certain claims that were uncontested render that party a prevailing party. Because if you were to go down that road, then the parties that made claims for declaratory relief where there was really no contest would be able to secure their attorney's fees. So it comes down to contested issues. And these two elements of the consent decree, or two aspects of the confidentiality agreement that are in the consent decree, were not disputed, and therefore they can't give rise to fees because there was no prevailing party as it relates to those two aspects of the confidentiality agreement.
All right. Thank you, Mr. Bebo. Time's up. Thank counsel for your arguments here this morning. We'll take this matter under advisement, issue a written decision in due course. Thank you for attending, and have a great rest of the week.
Thank you.
Thank you.